First of all, I want to welcome you and to thank you again for having accepted my invitation to make today a presentation for us and to share with us your very, very big experience. You allow me to present you in Greek?
Of course.
Thank you. Λοιπόν, σήμερα τη διάλεξη, που είναι η πρώτη διάλεξη της χρονιάς, καλή χρονιά και με την ευκαιρία αυτή, και δημιουργική και με υγεία πάνω απ' όλα και πολλές διαμεσολαβήσεις. Είναι λοιπόν η πρώτη διάλεξη του 2022 και η τρίτη διάλεξη του τρίτου κύκλου διαλέξεων που διοργανώνει η Ελληνική Ένωση Διαμεσολαβητών μαζί με τον ΟΠΕΜΕΔ. Ο ομιλητής μας σήμερα λέγεται Jeffry Abrams, είναι δικηγόρος, διαιτητής και διαμεσολαβητής με μεγάλη διεθνή εμπειρία. Σπούδασε νομικά στη νομική σχολή του Πανεπιστημίου του Χιούστον των Ηνωμένων Πολιτειών της Αμερικής και έλαβε άδεια ασκήσεως της δικηγορίας το 1982. Άρχισε να ασχολείται με τη διαμεσολάβηση το 1989, ενώ από το 1993 ασχολείται αποκλειστικά σχεδόν με την διαμεσολάβηση. Αυτό είναι πάρα πολύ σημαντικό και γι' αυτό έτσι λίγο το υπογραμμίζω, διότι ο Τζεφ άφησε τη δικηγορία, έχει δικηγορικό γραφείο και σήμερα, αλλά η ενασχόλησή του με τη δικηγορία αντιπροσωπεύει ένα πολύ μικρό ποσοστό πλέον της δραστηριότητάς του. Άρα είναι ο πιο κατάλληλος άνθρωπος για να μας πει πώς μπορεί κανείς να προσελκύσει κόσμο στη διαμεσολάβηση και να προωθήσει τον θεσμό. Έχει κάνει μέχρι σήμερα 6.000 διαμεσολαβήσεις με αντικείμενα πάσης φύσεως. Έχει καλύψει όλη την γάμα των αντικειμένων. Ο Τζεφ έχει κάνει πολλές παρουσιάσεις, όπως η δική μας σήμερα κατά βάση, σχετικά με τη διαμεσολάβηση στο Τέξας και ουσιαστικά στις 5 υπήρους, για να είμαι πιο ακριβής. Ήταν πρόεδρος της Εθνικής Ένωσης Δικηγόρων Διαμεσολαβητών και πρόεδρος του παρατήματός της στο Χιούστον. Υπήρξε πρόεδρος του Τμήματος Εναλλακτικών Μεθόδων Επίλυσης Διαφορών του Δικηγορικού Συλλόγου του Χιούστον και μέλος του Διοικητικού Συμβουλίου του Κομιτιακού Κέντρου Επίλυσης Διαφορών Χάρης. Συμμετείχε πολύ ενεργά και έκανε πολυάριθμες παρουσιάσεις σε πολλά συνέδρια του World Forum of Mediation Centers της ΟΙΑ, Union Internationale des Avocats, από τότε που ιδρύθηκε το κέντρο αυτό το 2001. Θα μου επιτρέψετε να σας πω ότι είμαι και εγώ μέλος του World Forum. Εκεί γνωριστήκαμε με τον Jeffry και συγκεκριμένα στην Πράγα γνωριστήκαμε και έκτοτε συναντιόμαστε πολύ συχνά. Και το World Forum of Mediation Centers είναι πάρα πολύ δημοφιλές, κάνει πάρα πολύ καλή δουλειά. Κάποια στιγμή λοιπόν, νομίζω ότι ήταν το 2009, έβαλα υποψηφιότητα της Αθήνας για να γίνει το επόμενο, το μεθεπόμενο σεμινάριο, έτσι γίνεται η διαδικασία, να γίνει στην Αθήνα. Λοιπόν, πολλοί ενθουσιάστηκαν, άλλοι δεν ενθουσιάστηκαν, αλλά δεν πειράζει. Και τελικά η Αθήνα πήρε αυτό το σεμινάριο και το οργάνωσε τον Μάρτιο του 2011 στο ξενοδοχείο Royal Olympic, όπου γνώρισε μια τεράστια επιτυχία. Ήτανε πάνω από 150 οι συμμετέχοντες από όλες τις χώρες του κόσμου. Jeff, I'm speaking about the seminar of Athens, of the World Forum.
Oh, wonderful.
Πάνω από 150 συμμετέχοντες, πολλοί από την Ελλάδα, το οποίο ήταν πολύ ευχάριστο, και πολλοί από όλες τις χώρες, όποια χώρα μπορείτε να φανταστείτε. Οι ομιλητές ήταν πάρα πολύ καλοί, μεταξύ αυτών ήταν ο Τζεφ, και θεωρήθηκε μετά το τέλος του συνεδρίου αυτού, εκτιμήθηκε από τα γραφεία της Union Internationale des Avocats που βρίσκονται στο Παρίσι, εκτιμήθηκε ως το καλύτερο μέχρι τότε σεμινάριο του World Forum. Κάτι για το οποίο τότε είμαστε πάρα πολύ υπερήφανοι, τώρα έχει λίγο ξεχαστεί, αλλά δεν πειράζει, στα κατάστοιχα της ΟΗΑ παραμένει. Ο Τζεφ έχει λάβει βραβεία πολλά για διαμεσολαβητικές υπηρεσίες και δραστηριότητες του από την Ένωση Δικηγόρων Διαμεσολαβητών, το Κομιτιακό Κέντρο Επίλυσης Διαφορών Χάρης, στο οποίο αναφέρθηκα προηγουμένως, από την Ένωση Δικηγόρων και Λογιστών για τις Τέχνες, με έδρα το Τέξας. Ο Τζεφ βαθμολογήθηκε. Δεν ξέρω εάν γνωρίζουν όλοι οι συνάδελφοι που είναι εδώ παρόντες, την Martindale Hubel, που είναι ένας διεθνής κατάλογος δικηγόρων, είναι πρώτος στον κόσμο και είναι μεγάλη υπόθεση να είσαι σε αυτόν τον κατάλογο, γι' αυτό και στοιχίζει και πανάκριβα. Λοιπόν, ο Jeffry έχει βραβευτεί με τον ανώτατο βαθμό. Έχουν αξιολογηθεί οι ικανότητές του και ο επαγγελματισμός του από την Martindale Hubel και γι' αυτό τον βράβευσε και γίνεται αναφορά στο όνομά του σε πολλές δημοσιεύσεις για την αρτιότητά του στην διαμεσολάβηση. Τώρα πλέον, δηλαδή εδώ και 2-3 χρόνια, μπορεί και περισσότερα, θα τον ρωτήσω αμέσως μετά, κάνει διαμεσολαβήσεις τόσο online όσο και offline. Jeff, since when are you conducting mediations online?
Since the beginning of COVID.
No, 2020. When we started doing our presentations also through Zoom. So, Jeff, the floor is yours.
Ευχαριστώ.
Παρακαλώ, Jeff.
That's about all I know other than food. Spanakopita. Okay, well, I'm honored to be invited to speak to this very esteemed group of Greek mediators. Because that's all the Greek I know, I'll have to be doing this in English. If there is anybody has a question, sometimes I talk way too fast. If anybody needs anything, just let me know, raise your hand, just interrupt me. We're not supposed to do that as mediators, but sometimes it's necessary. So I leave that up to you. Also, I'm going to talk about various things, the history of mediation in Texas, which is a strong, long history, and about the mediation practice and how to try to improve it, and also some tips for mediation. I don't know how long it's going to take. I could probably talk about it all day. I might only think of things to say for a half hour. Time will tell. But that's a long time to hear one person speak. So I know Catherine had indicated to me that there'd be some time for questions, at the end of the presentation.
At the end, yes.
Okay. And so my preference, and you're the boss, my preference is that people have questions as we go along, then I can deal with them. But I leave that to you. I mean, normally
I have no objection.
Okay.
The participants prefer to put their questions as during your speech.
Okay.
They can ask you politely to put the question and interrupt you.
Sure. Yes, and just, rate.
Everybody speaks English.
Okay, wonderful.
Yes.
Okay, so we're going to, I'm sorry, go ahead.
Hi.
And when my time is running out, please let me know if we come to that. And if I'm not talking about a topic that you'd like to hear about as time is running out, please also let me know that as well, because I can switch around.
Okay.
But I'm going to start with the history of mediation in Texas, and it's a history that began a long time ago, relatively, for mediation. It's a history that I'm very proud of. People think of Texas and they think of crazy people with guns, and frankly, there are many of those, believe me. And people don't think about it as necessarily a peaceful state. But I believe that Texas has been one of the leaders in mediation in the world from the very beginning in the 1980s. And we have a very strong history in mediation since then. I'll back up a little bit before the history of mediation in Texas to talk a little bit about how mediation began. And some of you who have studied mediation and its history might have heard some of this before, but I think the credit seems to go to a professor from Harvard University named Frank Sander, who in the mid-1970s became interested in alternative forms of dispute resolution. So he started studying it, and he started having conferences. These conferences were important, significant conferences, and much came out of them. One of the first things that came out of them in the 1970s was the idea of what's called a multi-door service center. And that was a center whereby people who have any kind of dispute, any kind of conflict can approach, and there would be many doors that they could, the employees of the organization could send you to. Is mediation appropriate? Is arbitration appropriate? Would it make more sense to send you to an organization that handled certain social services, things of that nature? And Houston, ultimately, I think it was because of at the initiation of one of our Texas Supreme Court judges, decided, hey, why don't we have one of these organizations in Texas, or why don't we have some of them? And in 1980, the Harris County Dispute Resolution Center was formed. Harris County is the county that the city of Houston is in. And they have a multi-door service. And right now, even to this day, they do many, many mediations of many different types. But it became successful. And then I think it might have been a different Supreme Court judge said, this is really working well in the community. Why don't we think of doing something like this in the courts? Our caseload is very backed up. It is not working efficiently. It takes too many years to reach a trial. And so why don't we try to come up with something for the court system? So an appellate court judge and an academician wrote what we call the ADR Act. First, what they had to do was write the act. I think overall they wrote a very good act. Secondly, they had to find someone to help lead it through the legislature. So they found a legislator who liked the idea and submitted it to the Texas legislature. And the Texas legislature decided it was a good idea. So they passed the ADR Act in 1987. Now, what the significant aspect of the ADR Act was the act allowed the judges to order their cases to mediation if they chose. It was voluntary. And one of the big differences we will see, and I am very curious through this process, I hope to learn more about what's going on in Greece these days. I have kind of followed it along the way since my involvement with the World Forum of Mediation Centers, but I haven't heard about it in a while. One of the big differences between Texas mediation, much of the mediation in the United States, in England, really it seems a lot in the Commonwealth countries, Australia, Canada, is we have a lot of compulsory mediation. And I talk a lot about that. At some of the conferences Catherine has been to, I'm sure I talked about compulsory mediation. And it's been one of the most difficult things, it seems, to try to convince places all around the world that compulsory mediation is the answer. And I will explain to you the reasons that I believe so eventually. But that's really what the main part of the Texas Act was. And so then we had this act, and nobody knew about it. None of the judges really knew even anything about it. So another very important step, and I talk about these steps when I talk with other countries about their mediation practices and their mediation systems, is it was a good template, really, I believe, for how mediation took off. And I think there are other states that have the same provisions as Texas, which allow the judges to order the parties to mediation. And in other of those states, the judges just don't do it. So there's really not very much mediation at all in those places. But what happened in Texas, which was important, was a group, what I call champions for mediation. And I know they have every place there's mediation, you have champions of mediation. I'm sure that Catherine is one of the major champions of mediation in Greece, and they're in various other countries. And I imagine we have others here as well. But what was really important is this group of champions, very well-respected lawyers, very well-respected litigators, judges, mediators, academicians, kind of formed this group and put on what we call a dog and pony show. I don't know if that translates, but here's our little act. Here's our little presentation. And they were talking about the benefits of mediation. And so they approached the judges, who were the ones who had this power, who really probably at that point knew nothing about what mediation was all about, but who also were having difficulties in their court systems. And they said, hey, look at this group we have. They're a very impressive group. Let us come talk to you. So they went, and it started in Dallas, Texas, actually. And they went around and talked to the judges, and they brought some of the most prominent lawyers and judges with them. And so the judges who were hearing the presentations were very, very impressed. They needed help. And so some of the judges in Dallas began ordering their cases to mediation. Again, they didn't even know that they had that power, but they liked the presentation so much. The initial mediators that were chosen were a very, very limited group, and they were the most experienced and recognized litigators in the Dallas area. So the judges were impressed. The judges were comfortable ordering these mediators to mediate their cases that they then began ordering. So they started mediating the cases. The lawyers went kicking and screaming, as we say, like lawyers do all around the world when confronted with mediation. One of the greatest difficulties, and I'll talk about this at some point as well, and I probably annoy some people sometimes when I talk about this, but what I have discovered, generally speaking, is when the lawyers are the gatekeepers of whether the parties go to mediation, mediation, generally speaking, doesn't take off. It doesn't get particularly prominent. And I'm hopeful I'll hear something different about what's going on in Greece. But the reason is, and I think we all understand this because most of you are probably lawyers also, is there's a fear of mediation in the legal community. This is going to steal our practices. We are going to lose money. We are going to go out of business. And the only reason, in my opinion, that mediation took off in Texas and in many or most other places where there is significant mediation is because it was compulsory. Because if you ask a lawyer if they want to go, they're going to say, no, of course we don't want to go. You're insulting us. You're telling us we don't know how to negotiate. You're asking our clients to pay even more money. And we don't need that. We're fine. So, but in Texas, finally, now that they convinced some of these judges that they could order the mediations, they started ordering the mediations. The mediations were very well trained, very well respected. And to the great surprise of most of the lawyers, the cases began to settle. And so then the more Dallas judges ordered more mediations, and then more judges. And then they came and changed the group a little bit, and they did that same dog and pony show with the judges in Houston. This was probably in 1988. 1989 at the latest, I would say. And they, again, put the best litigators together and went around to the judges. The judges were hearing from the judges in Dallas, and this was really working. And so they started mediating cases. They started ordering cases to mediation in Houston, and the same exact thing that happened in Dallas happened in Houston. They were going really, really well, and more judges started ordering more mediations. And the lawyers were just surprised. The stories you would hear is, I never thought that case would ever settle. I didn't think there was a chance in hell that that case would ever settle. And they were settling. We know the process is good. I wrote a paper once a while back that I can't find anymore. And the moral of the story was, to know mediation is to love mediation. But if you don't know it, you're not going to love it. And if you're not going to do it, you're not going to know it. And if generally you're not forced to do it, you probably won't. But when forced to do so, and a lot of people disagree with me, but this is my experience in Texas and many places around the world where mediation is compulsory. The lawyers learn about it, they love it. Many lawyers said, I love this process. How do I become a mediator? And so many of the lawyers who went through the mediation process became mediators themselves. And so what then began to happen is the pie began to increase. There was what I call the handful of five at first, and they were ordering all the parties to go mediate with these five lawyers because they were the best trained. And then it got so popular that we needed to train more mediators and train more mediators. And for the first few years, the training regimen was very, very extensive. You had to be a lawyer for 10 years. You had to have a letter from a judge that said you were a good lawyer. You had to have a letter from a colleague who you had a case against that said you were a good lawyer. And so, especially at the very initiation, the people who were conducting the mediations were very experienced. And I think also that really, really helped the spread of the mediation because the cases were getting settled. And so then the pie got bigger and the pie got bigger and the pie got bigger because we needed more mediators and more mediators. And so mediation has become just part of the litigation system. It's expected. The lawyers know they're going to have to go generally. Not all of the judges order mediation, but I would say a large majority of the judges do. Let me turn off my phone to see if I can get rid of that ding. Okay. And so what began happening initially is, so you had this new process that judges didn't know about, that lawyers didn't know about, that their clients didn't know about. And so what began happening initially is the lawyers would only choose from, well, turning off my phone didn't get rid of the ding, so I apologize for that. So initially, the judges would order every single mediation to a particular mediator because they only trusted certain mediators, and you had to take this very extensive training and you had to be on this list of mediators. And it worked very, very well. But eventually, there were so many mediations that were necessary, and there was a need for so many mediators that the pool of mediations and the pool of mediators began to expand. Then what happened is mediation became so popular, let's say. It became so common. The lawyers seek it out. They expect it. Even if the cases are not ordered to mediation, many, if not most, litigators will send their cases to mediation now because they've seen the value of the process. But mediation has become so popular that, for example, I've been doing this since 1989. I can have thousands and thousands of mediations that I've done. There's probably 50 to 100 other mediators in Texas who probably have also thousands and thousands of mediations. I know lawyers who, as lawyers within the mediation process, have been through more than 1,000 mediations themselves. So it began to change. Rather than providing an order for each case and ordering a particular mediator, the process now is the judges have what we call the docket control order, and that lists all the relevant dates for the purposes of the case, when all what we call the discovery is to be completed, all the information gathering, and then you have the trial. And within that time frame, and the parties are ordered to do this, it says you must complete your ADR by X date. Now, ADR pretty much exclusively in our context means mediation. There's really not very many other types of mediation that go on through in the court system. Now, a lot of cases have arbitration clauses in them in the disputes, so those cases will eventually go to arbitration. But the process that is used through the judges is really almost exclusively mediation. And so what will happen now is that the lawyers will contact each other. The opposite lawyers in the case will contact each other, and they will say, okay, we have this mediation date. Who do you want to use? And one will send their list of mediators, and another will send their list of mediators, because now mediation is so popular. Each lawyer has the mediators they like and the mediators that they don't like. And so they'll just talk and they'll agree. A problem that happens occasionally, but surprisingly little, is the lawyers are so against each other that they can't agree upon anybody. You know, if you want them, I don't want them. And so on occasion, and very rarely, you can't get an agreement on who the mediator should be. That is one of the circumstances where you can tell the judge we can't agree upon a mediator, and the judge would order a particular mediator to mediate that case. What is perhaps surprisingly common is I hear this time and again from lawyers. They'll say to the other lawyer, you choose the mediator. Whoever you decide, I'm okay with. And the reason for that is, their thinking is oftentimes, well, we have a pretty good case, and I want somebody that other side will listen to. And if they got to choose the mediator, I might well be able to convince that mediator of the strengths of my case. And so that lawyer is likely to listen to his or her mediator more than somebody that I chose. So that happens regularly. And so the large majority of cases now get mediated before there's ever a trial. Still, the largest number of cases will go to mediation and will settle in mediation. The large majority of cases still settle prior to trial. It was really, frankly, that way before mediation. It is still that way. And so sometimes people say, well, what's the benefit of mediation? For me, there are obviously many benefits of mediation. But one of the main benefits is what we would usually say is, because, you know, we have our jury system here in the United States, and probably the significant majority of cases got settled, as we would say, on the courthouse steps. All the work would be done, all the money would be spent. Sometimes people were afraid to go to trial. They didn't want to let 12 strangers make a decision for them. And so they would all settle at the courthouse steps. They would almost always be unhappy because it was something they didn't want. They have already spent a lot of money, and then they're getting something they don't want. And so for me, one of the best things about mediation is it has moved that date back, often significantly. People will come to mediation regularly before they've spent most of their money. On occasion, they get there too early, and there's not yet enough information for the parties to fully evaluate their case to decide whether or not they should settle. But many, many times, if they get to the mediation early enough within the litigation process, then they can still settle their case. And just because you have gone through a mediation that's too early it doesn't mean your use as a mediator has not been worthwhile. Number one, you have helped them identify what are the outstanding issues. They then can go throughout the case and concentrate on those issues. When the case becomes developed more, then they'll often say, hey, Jeff, we're ready again. I had another one of these very recently. It was just too early. The parties were too far apart. I don't remember, $20,000 and $500,000 or something like that. And it was just clear there was not enough information because it was unclear who was right or who was wrong. There was not enough information yet developed in the case to make that determination. And as a mediator, you can stay involved. And that's one of my best suggestions, my tips for how to conduct mediations and also, frankly, how to help build a practice. And so the majority of cases go, the majority of cases spend less money, the majority of cases settle long before they would at the courthouse steps. So I have no idea how many mediations that have existed in Texas or have taken place in Texas. I would have, over the last, it started becoming more prominent in 1989, which is when I started. There's probably been a couple million mediations conducted in Texas, for all I know. I don't really know for sure. There could be significantly more than that. But that's how mediation progressed. And mediation in Texas, we use, and I'll talk about this, maybe I should talk about this now, but, and this so much depends on the context of your mediation, what you're actually mediating, what are the facts, what's the type of the dispute, and things like that. I've done mediations of almost every conceivable variety. I started as a community mediator. I've done nonprofit mediation, but the bulk of my practice, the bulk of my thousands of mediations are cases in the courts, and the parties where the parties are required to go. And so generally speaking, throughout the United States, and I think throughout most of the places where there's a lot of mediation, not all, and I would always love to learn more about places that are not using the caucus model that are having a great deal of success. But in Texas, we almost exclusively, in the kinds of mediations that I'm talking about, the kinds of mediations that I'm doing, which are court related, sometimes before trial, even sometimes after trial, we almost exclusively use the caucus method. And I have a bit of a pet peeve, if that term translates. And one of the things I talk about when I go around the world and go to these conferences and speak is I think there is a prejudice in much of the rest of the world against compulsory mediation. I believe it's because I think the parties who started, the people who started going around the world trying to convince people about mediation and say it's a good process, many of them, the academicians, I would say predominantly, believe that what I do is not mediation. It's not real. It's not really appropriate. You know, everybody needs to stay in the same room the whole time and everybody can work out their issues and they should draw pictures of how they're feeling and that's going to resolve a complex business dispute. Where there may be difference amongst all of you, and I'm not intending to offend anybody, but that's the process that's used almost in all the places where in the US, and I think most of the Commonwealth countries, who are doing lots and lots of mediation and generally for compulsory mediation. I remember, Catherine, I don't recall if you ever met Helena's former law partner, Marianne Bastin,
yes.
who wonderful, wonderful person. And we had this discussion. I've been having this discussion with so many people for so long. Well, do we only use the conference model? We all stay in the same room? Do we use the caucus model? Do we use compulsory mediation? And Marianne told me at some point in time, she's from Belgium. She said, we've been conquered so many times over the centuries that we don't want anybody telling us what to do. One of my personal beliefs is if you want to have a significant mediation practice, you need to try compulsory mediation. There's other things that need to go on as well. You have to have well-trained mediators. You have to have lawyers who are willing to actually engage in the process and have their clients consider settling the cases, listen to the mediator, work through the process. But so that's what we do. For many, many, many years, and this might shock some of you all, but for many, many years, we would all start, even in the caucus model, we would start with an opening session, and the mediator would explain the process, and the parties would give their perspectives. We'd talk about it as long as that made sense. And then we would split into separate rooms, and the mediator would shuttle back and forth between both rooms, learning information, passing settlement offers, talking about the risks of going to trial. So at the end of the mediation, on the one hand, the client would have the other side's best offer. On the other hand, they will have had a thorough discussion of the risks of what happens if they proceed with litigation. Are they likely to do better than the other side's best offer? Or are they likely to do worse than the other side's best offer? And with the best offer and a thorough discussion of what the possible risks are, what I guess we call reality testing within the mediation process, they then make their decision. So many lawyers have been through so many mediations now that most of them want to skip the opening session. We know what the case is about. We know what they're going to say. They're going to get on our nerves. It's going to make the mediation process harder. So let's just skip. Let's go right into caucus. And you know, I've probably done, I don't have any idea really, but since COVID, and maybe I've done 350 mediations. All of them on Zoom except one. And maybe there have been 5 or 10 opening sessions. Now, I'm still a believer in the opening session. I think it's very positive. Almost 10 years ago, I gave a presentation to the lawyers in Houston about what I entitled the vanishing opening session. And it was, the opening session was beginning to vanish. We don't need this. And I was arguing to the lawyers and to the mediators that the opening session is still very valuable and we should not let it disappear, because it's just a good opportunity to present your perspective to the other side and for them to get the same opportunity to do the same for you. There's a lot of information you can gather. You can kind of distill the major issues so that you know what to work on throughout the course of the mediation. But now we don't really have very many opening sessions at all. And honestly, I haven't seen any significant difference in cases that have an opening session, in cases that don't have an opening session. And I think that surprises people. 5 years ago, I had a mediation, and I think it was an insurance representative from California came, and we had an opening session. And she said, well, you people in Texas are the only people still having opening sessions around the country. And I don't really know what's going on in all the other states, but that has happened. And I haven't seen any problem with it. Honestly, I haven't seen any detriment to Zoom. You know, I've had a 5-party mediation here or there. You know, most mediations are 2 parties, 3, 4, 5. Honestly, it's easier to conduct a 5-party mediation on Zoom than it is even in person. And at some point, I'll probably talk about Zoom. I don't know what y'all are doing. I'm curious to hear that as well. But the process that we use is very particular. And again, I'm talking about this particular kind of mediation, the mediation of lawsuits in the courts. You know, the promise of mediation, as they say, is let's salvage relationships. And if there's a business relationship that has soured, as we say, let's try to see if we can get them back on the same page. Let's see if we can get them to do business again, and heal their relationship. That's still the promise of mediation. And it can work, and it does work occasionally. But it doesn't really work that often in the context of the mediations that I'm doing it every day that are court related. By that point in time, they've talked, they've tried, it hasn't worked. They've hired lawyers, they've spent money, they've taken strong positions. They don't really like the other side at that point in time. And the ability at that point in time, after that amount of time and that amount of money and that amount of dissolution, let's say, they just want their case resolved. I mean, you got to ask yourself, and this is another thing y'all could answer for me too, is how often in the cases in court in Greece are the relationships established again, with mediation or without mediation? And it's always the goal. And even if I'm in one of these mediations where I think they really just want to get the case resolved and move on with their lives, I'm always looking for the opportunity to salvage relationships. I think that's the mediator's job. But I think if you try too hard, again, in the context of the mediations that I do, if you try too hard and you think your job is to, we got to maintain the relationship, I think there's cases that you will not settle. You will, people who are lawyers who are experienced in mediation, they'll say, no, we don't want that. Just help us get our case resolved. It's, I don't like to use the word cold and calculated, but it's very precise. There's a particular purpose that they come to mediation. They want to get their case resolved and they want to move on without spending more money, without taking more risks. The mediation practice that I have, I think like really everywhere, is a market. And we will talk some about marketing. The mediation practice, it's a market. And I get 95% of my cases, I would say, from the lawyers. And so the lawyers have expectations about the mediation process. They have expectations about the mediators. Honestly, if I tried too hard to try to salvage non-salvageable relationships, when people, okay, let's see. Okay, there she goes, she muted. Then the lawyers would say, I'm not going to go to Jeff because he's trying to always salvage our relationships and we don't have any interest in that. We want to move on. It makes sense. Certain cases are clear, and I've done a broad range of cases. Too many different types probably to state, but just take a simple case. And I don't know what the status of the law is in Greece as it relates to injury cases, car accidents, people falling on people's property, people getting hurt at work or in other places. And you're dealing with a company and an individual who's been hurt, or you're dealing with an insurance company and an individual who's going to be hurt. There's no relationship to be salvaged there. The insurance company wants to know how much they're going to pay, and the plaintiff wants to know how much they're going to pay. And can they come up with enough money? More often than not, and again, this kind of goes against the perception of the promise of mediation. But so often, not always, but so often, it's about money. You mess me up in this way. You've harmed me in this way. You owe me. No, I don't. I haven't harmed you in any way. And so really what I do in this context, again, if I was back in my days where I was doing community mediation and I was mediating between neighbors who had a tree branch in the other guy's yard, or whose dog was barking, or the roommates who split up and they wanted to see who got the stereo, or the couple who split up and wanted to decide who got the ring. Those are more interpersonal. Those are not litigation related. You might even be able to build relationships. And the conference model, from my perspective, is very appropriate in that context. The crux of the dispute is always the parties, but the role that the mediator plays can differ depending on the context of the mediation. In those, I would use the conference model. Everybody stays in the same room. You caucus only if absolutely necessary. As the mediator, you probably say as little as possible, and you just try to facilitate the discussion of the parties, which is good and important in every single mediation. Now, again, if you're not having the opening session, then you're not going to have that. Then the mediator becomes the messenger. But in the context of the kinds of cases that I'm mostly doing, where the parties come to mediation, they'd like to get it resolved, they'd like to avoid a jury trial, the role of the mediator changes significantly. I might as well, I was going to talk about this at some point, but let me talk a little bit about the different models of mediation. And I think depending on the type of case that you're mediating, you can choose what model is appropriate. So the trainings I've got training in, let's say the caucus style mediation, which is what I do. That was the first training I had. Shortly thereafter, I had the caucus model, the conference model training, because I was mediating community disputes. And then I also took a training at one time in transformative mediation, which some of you have probably heard of. I never conducted any transformative mediation, but it is the type of mediation where the mediator is least involved. And they talk about the two landmarks, or whatever the appropriate word would be for transformative mediation, are empowerment and recognition. Just by your actions and your occasional comment as a mediator, you're trying to empower the parties to be able to deal more appropriately with their case. People come into mediation and they're stressed, they're in a conflict. And part of it is just trying to help relieve that stress, because if the stress is relieved, then we as humans are better able to deal with any circumstance. And recognition is trying to point out those parts in the mediation where you're hearing one party finally recognize something from the perspective of the other party. And so you build on that, But that is the least involved type of mediation. I remember one time when I was taking my training, and they're saying, whatever you do, don't direct, don't do anything that appears in any like direction. And so I was a little skeptical because of all the mediation I had done. And so I asked one of the trainers, I said, okay, if I'm in my mediation and this person went first and I'm looking at this person and then they stop talking, if I look to this person to say, okay, it's your turn, is that too directive? And that trainer said, yes, that's even too directive. So that kind of surprised the heck out of me. And that's probably why I don't really use that. The conference model is the next in line. And in the conference model, which is, I think, the model most places of parts of the rest of the world use, is everybody gets in the same room. You use caucus as infrequently as possible, and you just try to open up the lines of communication. And for a case, I think that's appropriate for that. And I believe there are cases that are not appropriate for that, and cases that are hard to settle with that model. And we can talk about that. Really what I do is I take a very small role. And what I have found in those mediations, in those particularly interpersonal mediations, is when one person finally, after a dispute arises, because as we know, when a dispute arises, the lines of communication break down. And so once the lines of communication break down, nobody can get through a whole thought. And that's why one of the most important parts of mediation is don't interrupt. And so when one person finally gets to say for the first time, and who knows how long, what they want to say from the beginning of the sentence and thought to the end of the sentence and thought, they feel better. They're empowered in that sense. I finally got out my perspective. What happens on the other side, from my perspective, is when hearing for the first time the other side's perspective from beginning to end, which they hadn't done in a long time because they always interrupted, there was a greater understanding. They heard a point. They heard a few points. That's, I didn't realize that. Now that I hear the whole story, I can understand a little bit more where they're coming from. And when you let the other person then say what they want to say from beginning to end, and they feel better because they got to complete their thoughts, and the other side gets a better understanding finally of where that party is coming from, I say regularly that's 75% of the process. And then you just kind of direct the conversation, and more often than not, it will lead to agreement, better understanding, more empowerment. It'll lead to a resolution of the case. And I'm still open to doing those kind of mediations. I don't do them very much anymore. But for the kinds of mediations that I do, which I'm thinking would be the kinds of mediation that you all would do, or maybe that you all do, are cases in courts. It's wonderful to get a case that's not in court. Frankly, the biggest market is the market of cases in court. And that's the kind of case where, generally speaking, they want to try to get their case resolved. And so my role as the mediator in that caucus model is very much more involved. The reality testing phase of the mediation grows extensively. Imagine you have, and you deal with this in your litigation. There's litigation all around the world. You have, let's just say, two parties. And this party says, I'm right. I can't possibly lose this case. And sometimes their attorney is agreeing with them. And then the other side is saying the same exact thing. I'm going to win this case. And their lawyer is saying the same thing. And we all know at least one of them, if not both of them, are wrong. A quote somebody told me one time that was by Voltaire. He said it much more elegantly than this, but he said something like, I've only been ruined twice in my life. Once when I lost a lawsuit and once when I won one. And so the litigation process is not a happy process. And it's one that is often worse for both sides at the end of the day. But if you come into mediation and you can't do something to get the parties to come off of their hard positions more strongly, you're never going to get a resolution of the case. And so the role of the mediator in the litigation mediation, the way I describe it sometimes is I have to try to convince the parties, or make them think, not convince, at least make them think, make them wonder, make them doubt that their case is not quite as good as they thought it was. Maybe they'll win, but maybe they won't because of this and this and this. But I have to do it in a way that they're not going to hate me and they're not going to turn me off. So I try to convince people that the case is maybe not as good as they think, that they have more risk than they think, without turning them off, so they continue to listen to me. And then what happens is the parties come closer and closer together. And eventually they get so close together, it either happens naturally or they get so close together, it's kind of like magnets. And, they're that close, and then they will finally come together. But why I believe in this context that this model is so important is because if I'm having to talk about the risks in a case, so I'll go into one room and I'll say, okay, I know, here, tell me about your case. Well, what about this? How about this fact? What about this element of the law? And I don't know all the answers. I don't know any of the answers. My job is to raise questions in their mind. What might, in our context, the jury do? In our context also, what might the judge do? Because the judges make some rulings too. In your context, what might the judge do? Who is this judge? Does this judge have a particular way of being? Are they more for the defendant side normally? Are they more for the claimant side normally? And I know you don't think you're going to lose, but you didn't have a signed contract. Now, in Texas, you can have a contract without having a signed contract, but it just makes it riskier. And so what I find about the difficulty in the conference model in let's say a business dispute or a lawsuit related mediation is, how can I talk to one party or the other about their risks while everybody's in the same room? Because I then have a discussion with one side. How about this? You don't even have a signed contract. And the other person is there listening. And, oh, wait, that's a good point. They don't have a signed contract. I'm going to win this case. So what I can do when we've separated the parties out, I can have that thorough risk discussion with them. And I can go to the other side and have that thorough risk discussion with them. A simple example. You think they owe you $100,000. They think they owe you nothing. Well, you know, maybe you don't have a contract signed. Maybe there's this particular fact. Maybe there's this issue of law. You know, maybe you win 100,000. I can't say you won't, but maybe you get nothing for these reasons. Maybe you should think of settling the case for $50,000 because of those risks. I go to the other room and I have the same discussion with them. You know, I know you think you're going to lose nothing, and you might. I can't say that you won't. Because of this fact and this fact and this fact, you don't have a contract, but you sent the guy an email that said, I owe you this money. It's not a contract really, but it's an acknowledgement that you owe the money. And so you might have to pay nothing. You might not only have to pay $100,000, you might have to pay their attorney's fees. So maybe you should think of settling for 50. And the case often settles at 50. And it just doesn't go there immediately. It's a process. I say all the time, unfortunately, the process in mediation in the way that we use it, and in so many other places with a significant mediation system, I lost my train of thought. So let me try to get back. So the whole point is you try to get the parties closer together. You discuss the risks, and more often than not, they'll settle in the middle. I remember what I was going to say. I tell them it's kind of like buying a car. The process of mediation in this context is kind of like buying a car, and it's a negotiation like any other. And I'll even use the examples. Our term for the opening price for a car is the sticker price. Okay, so the dealer always starts with their sticker price. And we all know, at least these days, maybe not so much because there's fewer cars and it's more of a seller's market than a buyer's market. Prior to this, the car dealer always starts at the sticker price, and then they're willing to negotiate down. As buyers of vehicles, we're never going to give our best price first. We're going to give our opening price. And then we're going to, you know, make a better price and a better price. Okay, here's your sticker price. I'm never paying you sticker price, but I'll pay you this. I'm never accepting that, but I'll come down off my sticker price. I'm still never taking that, but I'll come up off my offer. And it's a back and forth most of the time, which leads to a resolution. And think about it. You can't discuss strategy in the opening session with everybody still in the room, you know, and that's why the role of the mediator can be even stronger within that context, within the caucus style mediation. Well, you know, Jeff, we're asking for $100,000. They're only at $10,000. You've done this so much. We need $50,000. You know, if they'll pay us $50,000, we need it. What do you suggest? And I'll make suggestions sometimes, not uncommon. And so for people who don't do this model, I think a lot of the things that I say is kind of surprising and shocking. But these are the things that happen in the bulk of the mediations that actually go forward in the places, I think, where there are significant mediations. And I'm always open, as I've said, to hearing other great success stories when the conference model in these kinds of cases is just as successful. But that's why the role of the mediation is strong. The mediator is stronger. I kind of say there are maybe 3 types of mediators, and there's probably more. But one is facilitative, which is I talk about in the community mediation. I let them do all the talking. I barely say anything. On the other side of the spectrum, you have evaluative. Your case is horrible. You're going to lose. You should settle. And then there's one in the middle, which I call directive. Some people, I think of directive mediation as evaluative mediation. I see the two of them completely different. I am not an evaluative mediator because I don't know what a judge is going to do. I have no idea what 12 strangers are going to do. talk about the risks that they don't do what they want them to do. But I'm not going to say your case is right or wrong, because frankly, I don't know, and neither do you. You think you both know, and you think you're both going to win. One of you is wrong. Directive is more giving some advice about, you know, if you want this, then consider making this movement. Again, with the understanding that the parties are paying me to get their case resolved. Really, I am in some sense like the car dealership. It's going to sound horrible, but it's why the parties come to mediate. I'm a salesman also. I'm a salesman of settlement. And it's important to be able to close the deals, so to speak. I don't use any, you know, I'm always ethical. There's nothing I'll ever do wrong, or the large majority of mediators will ever do wrong. And I think if you want to, you're concerned about your rate of settlement, and you can say your case is horrible. I'm never going to do that. But I think it makes sense to say, okay, here's what you need. Why don't you think about this, or how about that movement? And so it's directive in that sense, and it's done on both sides. It's not one side or the other. There's no favoritism. I remain neutral throughout. But the parties have their needs and their expectations and their perspectives, and not unless they're both met at the end of the day, will you have any kind of resolution. So that's kind of mediation in Texas. That's where it began. That's how it's practiced. Does anybody have any questions before I get into? Go ahead. Okay, I can't hear you. Okay.
Thank you for waiting. Thank you for the presentation. I have this question. Is it appropriate to ask the members for the risk in the case they decide to resolve their disputation in a court when they are in the same room?
See, that's my point. I mean, that's the reason in a context where you're dealing with codes and who's right in reading the code, and what are the risks that their interpretation of the code is not going to be correct, and that the judge is going to go with the other side. And obviously, as I understand it, everything is codes in civil law, which is most of the world. And from my perspective, that you have that same dynamic. You know, nobody is going to admit the risk in front of the other person, and they certainly don't want you pointing the risk that you see to them, because then they think the other side's going to use it and they're going to change their filings with the court and made the argument that you made as a mediator. And, you know, there's the mediators have said, we have the same motto as the doctors: do no harm. Now, if I'm in a separate room, then I can say, well, what about this? I mean, look, you know, I had a case, such and such, and this happened, and blah, blah, blah. What do you think about that? And you make them think about it. And frankly, they're sitting there with their client. You're not trying to get the client opposed to the lawyer. The client sometimes doesn't even understand what the risk is, and the client's not going to move. If the lawyer says we have the best case and we're never going to lose, and the client thinks they're never going to lose, then they lose, it's too late. And so I don't think it's appropriate, really, but that's going to rely more upon y'all. I'm going to maybe curious of other people's perspective on this. We can make this a group discussion because we got some very good mediators in here. And if there are some people who discuss the risks within the conference session with everybody there, if you've had some success with it, why don't you share that? Or what your approach is to doing that with everybody in the room? Because my concern, as expressed, is, you know, you're going to strengthen or weaken one side or the other in front of the other, and that does not necessarily lead. You know, the other side may say, I was going to accept this, but that's a really good point, mediator. Now I want twice as much. Now, maybe there would be something about a balancing of a risk discussion with both sides. But, you know, sometimes cases, there's more risk in some cases than others. And sometimes cases have a lot of risk, and you can say a lot about the risk of one side, and there's not as much you can say about the risk on the other side. As a mediator, you have to come up with some other discussions about why it can be practical to settle. Are you going to spend a lot of money? Is this decision not going to be made for another 5 years? What implications does that have for your well-being and the benefit of you and the benefit of your company? Is it, even if your case is completely right, are you better off compromising today off of something you know you may win than waiting to win in 5 years? What are the consequences of that? It's a common saying amongst the mediators in Texas, and maybe it's mediators all over the country, and maybe it's all over the world. They say, we live in the question. We're not telling anybody anything. We're asking the questions. What are the practicalities? What are your chances of winning? What are your chances of losing? If you lose, how much will you lose? If you're going to win, how long is it going to take you to win? What are the risks you don't win? You know, try to get the lawyer involved in those things as well. You know, ask the lawyer, what are your strengths? What are your weaknesses? What do you know about this judge? What do you expect to happen here and why? Is there a chance that what you expect to happen is not going to happen? And in that kind of case, that's, in my opinion, from my experience, because I've done such a wide range of mediations in the first many mediations that I did before I started getting business were this community model of mediation with neighborhood disputes and things of that nature. And so I've seen the different models, I've used the different models, but there seems to be reluctance around the world. And so I go on my, when I talk a lot about this stuff because I'm concerned that especially in a context where the lawyers are the gatekeepers, and I'm probably going to want to hear more about that and what has changed, if anything, in Greece. Where the lawyers are the gatekeepers, first of all, you got to get them there, which is really hard. But secondly, you have to make them comfortable with the process. You have to make them think this was worthwhile. This is good. This helped me resolve a case that probably I wouldn't have resolved otherwise. Or this has helped me resolve a case I think I probably would have lost. And even in my business, even though the cases are court ordered, it's still a market. And I have to, if the lawyers don't like me, I'm not going to get any business. So if you go in there and you're talking about risks of the case in front of the lawyer whose client that is, and both of them, they're not going to be very pleased with you. And even if they have to go to mediation, they're going to probably use something else. One of the things, this goes to marketing. One of the things regarding marketing is this is a market, you know, like anything else. Now, in the context where maybe you have a really great reputation, and in a context where the judges are ordering the parties to a particular mediation, and the judge likes that mediator because they have a lot of success and they're well known, that's one thing. But in cases like in Houston now, where the large majority of cases are decided between the lawyers, if the lawyers don't like you, they're not going to use you and you're not going to have any business. Now, you don't do anything to make them like you. You don't favor them in any way, but you treat them fairly. You know, they appreciate you oftentimes, not always, but oftentimes, more often than not, talking to them about some risks they hadn't thought of, or talking to their clients about a risk that they hadn't thought of. Many times, lawyers will tell me before the mediation, hey, Jeff, this is a tough one. My client has unreasonable expectations and I need some help. And so then I can talk about the risks with that client. The lawyers are appreciative of that in a context where the other side's not hearing all of those risks. And so, you know, fortunately, I have a joke that I tell, but this is by Zoom, so you're not going to really understand the joke. But Catherine has met me, so maybe she'll understand the joke. I've said I've been fortunate over the years to be on a lot of short list of mediators. You know, people have a list of 3 mediators they like or 5 mediators they like. And I'm also on everybody's list of short mediators because I don't know how to convert this to meters. I'm 5 feet 3.5. So I'm diminutive. But it's a market. Again, it doesn't mean you do anything unethical, but you work hard to try to resolve every case. I have gotten many cases over the years from lawyers where cases didn't settle because they could tell I knew what I was doing. They know I worked really, really hard. I tried everything. I raised all the points that I could possibly raise. And for other reasons, the case didn't settle. Maybe it's too early. Maybe the other side is just completely unreasonable. Whatever the case may be, you know, Jeff, you worked hard. You did a good job. I'm going to come back and use you again on another case. And so that's my opinion. I am open to everybody else's opinion on this because this is where I have the biggest conflict.
Thank you.
Is on these kind of issues. I'm sorry, go ahead.
So much.
Christos.
Thank you. Yeah. Thank you for your excellent presentation so far. We are happy to have your advice. I would like to add, firstly, I agree with you that the mediator's credentiality is exposed when he asks about the risks of the case. But my remark is that during the conference session, each side, weak side, will be made clear by the opponent, by the other party. So in that way, I would like to ask, what if the mediator just transmits in a more elegant way the question that the other side has made, and in that way, his credentiality is not exposed. So do you think this is an effective way of facilitating the discussion after, in the end, we facilitate the discussion in that way? Because if I am on the one party and I am offensive by exposing the other party weak side, the other party will not defend in the way if I transmit the question in fine words.
That's a fantastic question. And I think that in the conference model, that is the only way you could possibly do it without being perceived to be biased. And we do know it's a really, really important part of our job to say things in a different way, because sometimes the other side just doesn't want to hear what that side has to say. Or frankly, sometimes that person doesn't say it very eloquently, but you as the mediator have a better understanding of what they're trying to say than they're able to explain. And that's exactly what you're talking about. And so all he's trying to say is, all she's trying to say is, and you explain it, and they might understand it for the first time. So that's, I think, a really important role of the mediator. I think the potential risk you have, let me make 2 points and then I'll come back. You have to make sure that within that retelling, that reframing, that you're not putting some of your own thoughts and biases where there's that risk that they think maybe you're biased towards the other side. And I'll also be honest about this. I mean, as a mediator, sometimes I have to come up with reasons and risks that the other side hasn't even thought about. Sometimes the lawyer's not prepared, and that happens all the time. And they can't explain the risks to the other side that they really have. So in the context of everybody in the same room, I can't sharpen the other side's perspective. Oh yeah, that's a good argument. I'm going to use that from now on in front of them. And so it's much easier to do that in the other room when people aren't together. However, that's a really, really good point. And to me, it would seem that the only way you could to do that together is in exactly the way that you talk about. But some things may be missed. And there may be some points that aren't made that you can't make, that maybe means somebody is not assessing the risk. And I'll say to them, I can't tell you I'm sure about this, but how about this? And what about that? And what risk does this create? And then let them, oh, you know, Jeff, I hadn't thought about that. Or, you know, this is a really, and I tell them, look, I'm not gonna tell this other side this. Here's a risk that I've come up with on my own, and it could be relevant. If you think it's a risk, then maybe you should, you know, take that into consideration deciding what you do. But obviously, part of the do no harm, I'm not going to go to the other side and, hey, have you thought of this argument? But no, I think you have the perfect answer for what you have to do as a mediator within that same room. But then, you know, maybe, and I don't know how much caucus is done there, if it's just frowned upon completely, maybe if you've done that and you see a situation, you see a risk that they're missing, you see something else maybe they should hear, then maybe you can say, look, I'm going to call a caucus, and maybe we can all come back together again. Again, whatever really makes the most sense. Nobody ever wants to come back together again in the kind of mediations that I do. But yes, that is the answer. And let me ask you this. Have you done it? When you've done it, how has it worked? Or anybody, really? I know you had some more questions.
I didn't have the opportunity yet, since I'm too young. But I would like, but the following question is that if we have a cunning, experienced lawyer on the other side, he will try to avoid the weak part, his weak part, even if I ask him. So again, the question is, would it be wise to insist, or would I sound too prejudiced to the party that I am asking?
Right, I think so. That's where that risk comes in, because the lawyers, you know, he thinks that's a big risk. I don't think it's a big risk, and it may be a big risk. You're right. If you do come on too strong, and then you have no other opportunity to have that conversation privately, you have to kind of know your lawyer, and you know, and maybe that lawyer, on rare occasion, it almost never happens, but on rare occasion, Jeff, I don't want you talking. I don't want you saying that. My client knows all that already. And maybe some lawyers will just be so upset at you, they'll say that, and they won't let you have those discussions. But, you know, the practical reality, as we know, is if you have lawyers who have zero interest in settling the case, for whatever reason, then that case probably doesn't settle. If you have a lawyer who is willing to take a look at what's in the best interest of their clients, and we know there's good lawyers and we know there are bad lawyers. If you have lawyers who seem to have the best interest of their client in mind, and they're willing to try to reach the best resolution for their client, they're more willing to listen to this and let you talk about that with your client. And so, yeah, I think you run that risk that you then start to sound biased. But I mean, part of the problem is I have these conversations and people will say it's impractical. We will never be able to have caucus model mediation. I would suggest that if nobody else is doing it, give it a try. You know, you have to market that. I mean, this kind of goes into the marketing aspect of the case. And if no lawyers are using it and no judges are ordering it, and there's no legislation that says it has to be done, then where do you find your business? That's part of the difficulty, of course. But so that what I would then say under those circumstances, you know a lot of lawyers, you've worked with them, you're most lawyers yourself, you have an idea of who the most reasonable ones are. And you approach a lawyer and say, hey, here's the deal, and here's this new model I want to talk about, and here's how it works. And you seem like somebody who might be interested. Are you interested in giving this a try? You almost have to hand pick the gatekeepers and to see if you can convince somebody to give it a try. You know, something you could think about, and here's something that I would offer. I periodically have people who will observe my mediations. And it's way easier to observe a mediation on Zoom than it is to fly in from Athens or wherever any of you may be. And if somebody has an interest in that at some point in time to see how a caucus model mediation goes, you're welcome to. While I'm thinking about it, let me ask, is everybody here from Athens, or do we have people from all over Greece on the Zoom?
All over Greece. We are from Thessaloniki.
Okay, where we had that wonderful conference. I call Thessaloniki the city of balconies. Seems like every single house in Thessaloniki has balconies. I got an Airbnb and it didn't have a balcony. So I got a different Airbnb that had a balcony, but then it didn't really have a balcony, and she lied to me. So I had to stay in my other room. But it was like, I wanted to see, you know, the beautiful water and things of that nature. I thought it was a beautiful city. And so I don't know, maybe you want to hear about, does anybody have any other questions in general about any of this at this point? I'm sorry, go ahead. That's Polixeni. How do I pronounce that?
Yes, you pronounced it well.
Okay. I'm better to be lucky than good.
For your valuable experience you shared with us. When it's about complicated cases, you prefer to have an abstract from the lawyers?
Yes.
With the bullets or the whole documentation?
That's another great question. Let me start out by saying, you know, not every single case I do is complicated. And that's fine. They still pay me the same amount. So that's good. And I would probably say in more cases than not, I don't even get materials from the parties. But they're the kinds of cases I've done many, 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 many times, and everybody's done many times. And it's not complicated to understand what's going on quickly. For a complicated case, I would always prefer to have materials, but I prefer limited. And let me tell you, I think for a couple of reasons, but I think it's probably going to be different there than it is for me. For whatever reason, the practice of mediation in Texas, and I think it may be different in Texas than in other states, developed as a flat fee for mediation. And so I'll charge each party a certain amount if it's a half-day mediation, which is 4 hours, or a larger amount in case it's a full-day mediation that's going the whole time. So personally for me, and I have a little statement I say, please limit your materials to 5 pages. And if you do happen to send me something, and you're sending me large documents, large contracts, we have depositions where they have the witness testimony and things, please highlight the relevant points for me, because I can't spend all that time going through a 50-page contract to try to find the salient points. And now, for me though, I'm not getting paid extra for reading it. And I'm not going to spend 2 hours, an additional 2 hours, unless perhaps if it seems absolutely necessary, then I'll do it. But there's a lot that I can explain from the mediation perspective as a mediator in a short presentation rather than boxes of documents. Now, I know others who charge hourly like to get boxes of documents because they can charge for reading them. But I don't think it's necessary to have extensive information. But, you know, people will send me the contracts and they'll underline the relevant provisions, or they'll send me a copy of the law and they'll underline the relevant provisions, or you know, of course we have case law. They'll send me the case, and that can be very, very helpful. I think in the context of the kind of mediation that I do, that I've been talking about, the lawyer's job, the lawyer obviously has a really important role, but the lawyer's job really on both sides is to arm the mediator. Because in a sense, this is going to sound strong, but it's the reality. I ask both sides, get me your best information, but get me your best ammunition about why your case is better than theirs. So that I could try to convince them that maybe they got more risks than they think. And when I do that with both sides, then there's that balance. I'm not favoring one side or the other. I go to one room and argue one thing extensively. I go 30 seconds later, now with Zoom, 5 seconds later, I say the exact opposite stuff with different elements of ammunition. If I can't convince the parties and the lawyers that there is some risk in their case, then the case will never settle. And so it's the lawyer's job to effectively present their side to me so that I can have what I need to raise questions with the other side. So that's my take on it. And frankly, if they send you boxes and boxes, you know, maybe you'll get paid for reading it all, but at the same point, it's a lot. It's a lot to distill. You're going to deal with this case for a day, maybe. And, you know, we have half-day mediations. You know, how much are you going to, they're better off. They're doing a better job as a lawyer if they can distill what the most important things for you to know in a manner that you'll be able to read it and understand it and express it. Any other questions at this point? I'm sorry, go ahead.
I just thanked you for
you're welcome.
the answer.
Paracalo. Okay, we've been used my entire vocabulary now. Catherine, did you want to say something?
Yes, I would like to put some questions. If
Please.
there are no questions from other colleagues. Έχει κανένας άλλη ερώτηση σε αυτή τη φάση? So, I put my first question, Jeff. When you say court-related mediation, you mean a mediation where a case where there is already a lawsuit pending before the court and the clients and the lawyers decide after they have filed the lawsuit, decide to go to mediation to leave pending the lawsuit until mediation is over? Or do you mean the cases where the court suggests or orders a mediation?
Both. So what I mean by court-related, it is the type of dispute that if it is not yet in court, is likely to go to court if it's not resolved. So that's what I mean. And, you know, you will have people, maybe they have a mediation clause in their contract. And so they're obligated to mediate before they can even file a lawsuit. In a sense, maybe court-related is not the right word. Maybe litigation-related would be a better word. It's just, no, it's not how it gets to mediation. It's where is the likely venue for this dispute if it doesn't get resolved. Now, for me, because the large majority of cases I mediate are already in court because they already have to be in court for the judge to be able to order it to mediation. Then so the large majority of mine are cases already in the courts, and the judges put the deadline and the parties contacted me before that, and then we set up a mediation, we conduct the mediation. Does that answer your question?
Yes, of course, but I have one additional.
Sure.
Does the court, may the court impose, make mandatory the mediation?
Absolutely. That was the whole purpose of the 1987 ADR Act, was to give the judges the power. And again, the difference between Texas and other states, which give the judges the same power because of the beginnings, because of what I've described as this dog and pony show to the judges, they were convinced it was a good process. They have the power and they choose to order it. Some judges don't believe in it, and so they don't order it. But yes, that's why it's compulsory, because the judges can order it and they do. So let me ask you this question. I'm not saying any of the judges in Greece would necessarily do this, but if a judge wanted to, could a judge order the parties to go to mediation in a case in their court?
No.
So they don't have that power whatsoever.
No. They have not this power. And the new law on mediation, which was promulgated in 2019, provides the obligation for many categories of disputes, almost all, we could say, the obligation to make a first meeting, a first attempt of mediation before the case is heard.
Okay.
That's it.
Right.
This is mandatory, but you may go to this first meeting, stay there 5 minutes and leave.
Right.
You have fulfilled your obligation, and that's it. There is no mandatory mediation. It is not allowed. It has been considered contrary to the Constitution.
So, okay, so in order then to change that, you would have to change the Constitution. So the law is such as if, I think what you're telling me is if the legislature decided they wanted to order parties to go through a full mediation, not just a 5-minute session, that would be unconstitutional, and the courts would rule that unconstitutional.
At present?
At present.
At present, yes.
Okay. So, Christos, go ahead, Catherine.
Excuse me if I interrupt you, but I want to make it clear. This first mandatory meeting has as purpose to lead the parties to full mediation.
Right, right.
The purpose. But because of the attitude of most of the lawyers, as you said, this is cut short very quickly.
Right, yeah, so if you can't compel the lawyers, who are that as I said, the lawyers, as you recognize, are the gatekeepers, and they'll not choose it. And so that's I think it's really, really hard. So you have to ask yourself, okay, I'm being grandiose, and I'm being, what's the word I'm looking for? I'm being, I'm saying things that are probably impossible. But the first question that comes to my mind is, if the legislature can't do it, they can't order the parties because it's against the Constitution, and the judges can't do it, how do you change the Constitution? Like in the United States, for example, it's a crazy question, I realize. And then I'm going to move beyond this because it's probably a crazy question. But I think it's an interesting question, just based upon my experience. So like in the United States, if you want to change the Constitution, you have to have 2/3 of the states. Exactly the same. All agree. Now, let me say this. All the states, all 50 states have their own constitution. If you want to change the constitution of a state, it depends on the particular state. But in Texas, for example, you could put a constitutional question on the ballot, and if more people say they want that constitutional change, then the Constitution changes. Now, I don't know, that doesn't sound like it's necessarily going to be how it works. Are there different states within Greece who have their own mediation provisions? Is there anything they can do within those states, any powers that they have to enable the judges or to enable their legislatures to do it? Or is it the national constitution which prevents it?
It is a national constitution. We have only one constitution.
Right, okay.
And
well,
so
what happened? So I'm curious about this because it's probably not reasonable to expect that, but mediation, as we all know, and we're all here because it's a great thing. And the people who hear about mediation love the idea of mediation. Now the lawyers don't, maybe all the legislators are lawyers, and so they never want to change this. But, theoretically, if you put it out there, is it the kind of thing that this is such a great idea that we want to change our Constitution in this way? The likelihood that that's going to happen is probably pretty small, but you never know. The key there, frankly, if you even want to think about beginning that process, just like we did in Texas, they wrote their statute first. They took their statute and they found a legislator they thought was would be amenable. They thought that legislator might agree to submit this legislation to the state legislature. And she did. And the state legislature liked the idea. And so they ultimately passed the law. So in that vein, you have to search out somebody who's part of the constitutional process and say, hey, this is a really good idea. Maybe it seems crazy, but here's why this is a good idea. Mediation's good. It's not going anywhere. It's not the compulsory mediation is not the horrible thing that you think. Now, that's probably unrealistic, but that's where I would start. And, you know, nothing ever happens if nothing ventured, nothing gained, as they say. And it would be, the key would be to pick out the proper person or persons to potentially present that. Again, probably unlikely. So the next question becomes, and this is going to go to the marketing aspect of this. When the lawyers are the gatekeepers, what can you do to go around them, frankly? Because I think you've seen that you can't get around the lawyers. They don't want it. First thing, as it relates to the lawyers, it goes back to what I was saying. Are there some lawyers that any of you each know individually that seem like reasonable folks who care more about the outcome of their client than they necessarily do about their practices? And you approach them and say, hey, here's this process. Do you have any cases with anybody else you think would be willing? I remember when I first started mediation, what would happen is this insurance company wanted to mediate cases. And they would send it to my boss. And they would say, hey, we want you to mediate this case. Call up the plaintiff's lawyer and explain mediation to them and see if you can convince them to do it. Now, tell them we'll pay, which is not really going to work in this kind of context. We would explain it and they say, hey, that sounds great. Let's give it a try. Outside of the lawyers, but that's really kind of my first step. Now, the question then becomes, and this is like a two-step question. Is there anything, if a judge can't order it, is there any kind of pressure that a judge would have the power to put on the parties to encourage them more strongly to mediate? Number one is the first part of the question. Second part of the question, is there any would do that even if they might have that power? Let's look at England. Let's look at the United Kingdom, for example. They still don't have compulsory mediation, as I understand it, but they do have a situation where the judge could recommend mediation. And if one of the parties chooses not to go to mediation and they go to trial, the judge can take their failure to not go to mediation in consideration when awarding costs. And even if they were the winning party, and they would normally get costs, if they didn't go to the mediation, the judge could not pay them their costs. I don't know if they could pay the other side their costs. I don't really know how that part goes. But that's a power that, it's not a power to order, but would a judge have that power to decide how costs go?
As a matter of fact, the judge may recommend mediation,
right,
to the parties, but the parties are absolutely free to accept or to deny with no consequences.
Okay, so what you're telling me is the judges then would not have the power to
impose,
award costs, not impose the mediation.
No, it does not go like in the United Kingdom.
Oh, I see. Okay. There are no costs like that. In effect.
No.
I see. No. The next point. So you got to look at your potential users. You got the legislature, and in this context, it's only the Constitution. So you have to decide: is it possible to approach it constitutionally? And let me also say this. This goes back to another thing I've said in many places. Let's talk about the champions. You got to put this group of champions together, this really respectable group. And so the question is, even if you thought of considering, can we approach this constitutionally? Two really important things. Who are going to be the people who do that? three things. What are they going to say? And who are they going to say it to? And so everybody wants to be a champion, of course, but some people need to give up the ego and say, I'm okay not being a champion because, you know, Catherine's more involved than I am. And so Catherine should be a champion because she has the ears of these people. Who else might be part of a group? Whether it's maybe, I don't know. I know the relationships between judges and lawyers are different in different countries. And here, you know, we can approach a judge. And as part of our champions, we had judges along with lawyers, along with mediators who created this group of champions that helped convince the judges to use this power that they now had. So the question becomes, who is the group? Can you put 3, 5, 7 people together, very well respected? What are you going to say about compulsory mediation and why it's worked? They're bound to be able to get amazing success stories from around the world at places that have compulsory mediation. And so you can figure out what you're going to say, and then you have to pick out the appropriate person or people to make the presentation to start the process. And so that's just one point. Now, but that same group of champions, so who are the potential audience? Potential audience is the legislatures for constitution and legislation. You have the judges. We talked about that they don't seem to have any power to do anything other than recommend, and there can be no consequences if they don't go. So the judges really aren't the audience for this unless you're trying to convince one or some of the well-respected ones who might be willing, and maybe nobody would be willing, to be part of the group of champions. That's how you would want to use the judges. The lawyers, again, you would have to try to find, you know, maybe have this same group of champions and handpick a few lawyers that you can think of who might be open to something like this. You know, a thought would be, if you go to some of the big firms, for example, and I don't know whether you have lots of big firms in Greece or not. You know, you go to London and you go to Paris, and I imagine in Athens you have the fresh fields and you have the, you know, all these large international groups of lawyers. Those international groups of lawyers who are more used to doing things on an international basis, or have colleagues who do things on an international basis, might be more open to it. They might have been forced to go to a mediation in Texas, have liked the process, and be willing to consider it. So then you try to find, can you find a group of lawyers who are willing to even try? And if you can, you have to make sure you know what you're saying, and you have to explain it well. And so that's another approach. Then the other approach is business. You know, we've tried to do this in the States with some success, but frankly, we've had a great deal. CPR is a big organization, Center for Public Resources, I forget. And they've got these companies to sign on to pledges. We will use alternative dispute resolution. So then they try to go through their companies and say, when you have an opportunity to do dispute resolution, do it. And so that's a possible audience. And you want to have a good group to talk to them. And I don't know that this would work, and I think it wouldn't. But the last potential audience is the client. The clients are potential audience with the business that I just talked about. But you have individual people. I mean, can you put commercials on television that explain the mediation process and tell the individuals, tell your lawyers to try this? Now, some of these things may sound silly, but if you can't talk to the audience who might do mediation and figure out a way to get somebody to try, it's never going to happen. So I think it's like constitution, legislation, judges, lawyers, clients. Those are your audience. How do you best try to approach any one of those? Could you, I don't think you could do this either. What I recommend sometimes in a situation where maybe the judges have the power to do something like that, or maybe a legislature would have the power to do something like that, get the same group of champions together. Hey, let's just try a pilot project. We'll try this for a year. And we'll do it on a limited basis with only so many cases. And let's do an experiment. It works here and it works here and it works here. And their caseloads have gone down significantly as a result of the mediation process. So can we start a pilot project somewhere, whether with the companies or even the lawyers or whoever might potentially be open to something like that. But you have to find an end user who is going to be willing to try it. It might be worthwhile, frankly, to even say, and I don't know that anybody wants to make the sacrifice, but if I were living in another country and I wanted to try to convince them to do that, or if I'm here and I'm mediating in another country, which of course I can do from here now, I would try to do the same thing. I think I would try to figure out, I would try to put this group together. Who can we talk to? How can we find the lawyers in some of the larger firms who have been through mediation before, who like it, and start trying to put the group together and the potential clients together and start selling it, because you have to sell it. And one of the point, even to the point of doing it for free. You know, you have a pilot project where we're going to do a compulsory mediation. We're going to go through this whole process. Of course, it's not compulsory. It would be voluntary under those circumstances. But we want to show you this process. Frankly, it's whether you use conference model or caucus model. I think in my long experience, I think, especially in businesses and especially with lawyers, they feel more comfortable talking privately. And that might be something that's hard to convince you all to consider. But hey, we're going to take 5 cases. We've got all these great people who you know already, and we're going to do this for free to show you how good this is. And one of the things about marketing with mediation, one of the best things about marketing your practice with mediation, especially in a compulsory mediation context, is when you're mediating, you're marketing. The reason I keep getting business is because I'm a halfway decent mediator. And one lawyer says, I don't care who the mediator is, you choose. So somebody who I've used before and likes me brings them to mediation. And if they like the job that I've done, they do the same thing with the next case that they have. So it all goes back to what I was saying before. It's to know mediation is to love mediation. But if you can't get them to know it, they'll never love it. So you're going to have to go outside of the box. You're going to have to find these people who might be amenable and, you know, even say it's for free, or say we'll give you a completely reduced rate, or whatever the case may be. Because one of the things I would like to try to convince legislatures of, for example, is let me say this, we don't really even have any significant licensure for mediators in Texas. It was completely the market. Any one of you could come to Texas tomorrow and, as we say, put out your shingle that says mediator and start mediating. Your problem is you're not going to get any business because you don't know anybody. If you do know somebody, you might start getting business immediately. But one of the main arguments for that is, and why the market has worked so well, is generally speaking, there's so little harm that a mediation can do. Look at the context of a large case that's going to be costing thousands, if not millions of dollars, and taking 5 years or however long the trial process is in Greece. You know, you're going to pay a mediator this amount of money and spend a half a day or a day. It's such a minuscule thing in light of the entire context. And there is so little harm that a mediator can do when you think about it, because doctors are licensed, because they can kill people. Lawyers are licensed because somebody can lose all their entire money or go to jail for the rest of their lives if they have a bad lawyer. The reason we get by with mediation not being licensed is because it's the market. The good mediators come to the top, the bad mediators go away. And the worst thing that can happen, especially in the in, I'll call the litigation context, where the lawyers are involved, is if you're a horrible mediator trying to coerce people and do all that kind of stuff, the lawyer is going to say, no, of course not. Go away. Leave us alone. And the worst thing they've done is they spent a little bit of time and they've spent a little bit of money, especially in context potentially to the size of the case. There's so little harm that can be done by a bad mediator or a bad mediation. And when you put it in the context of how much good it can do if people were really using it, then it really seems like a small thing. You have to, it's against the Constitution. Why is it against the Constitution? I know they've come up with reasons, but when you think of how small of a thing it is relatively and how little it's going to cost, it's, the harm is so small, it shouldn't be something that's violating people's constitutions by making them ask to consider before they clog up the court's time and they make the dockets bigger and bigger. It takes 3 years, 5 years, 7 years to get through trial. That is part of, I think, the discussion as well when you're trying to talk to people. It's almost like, what's the harm? Give it a shot. There's so much at stake. And so these are all, but the bottom line is you have to find an audience, and you have to figure out who they might be, and you have to go searching for them, and you have to convince them. I don't know, it sounds like it's been pretty tough there. I don't know. I'm willing to help in any way that I can. I mean, I love mediation. You know, we could give the US perspective. We could probably get judges to say how great mediation is, and how much success they have. The judges love it here. It helps them. It reduces their dockets. I don't know what the judges are like in Greece and whether they even want to give up the jurisdiction in a sense. I like having that case in my court. Or are there judges who say, man, I got too many cases. You know, it would be great to have some help. And maybe all of these things I'm saying are unrealistic, but the bottom line is you got to get the audience. Now, you also have to look at the worst case scenario is if somehow you find an audience and then you get them to order the mediations. If the lawyers if every single lawyer says, we don't really care, this is a waste of time, we're not even going to engage in it, even if you make us sit here for 4 hours, it's probably not going to be successful because their clients are generally going to listen to them. But if you go through the whole process and their clients are hearing the risks for the first time and getting an understanding for the first time that they may not win, they might try to convince their lawyer and say, hey, lawyer, hey, I do want to settle this case. So there's a lot of barriers, obviously, and there sounds like there's maybe even a lot more in Greece. I mean, what was the last attempt to try to convince people? Are there any other thoughts that anybody has about within the context that you have? You know, what possibly can be done? How do you find the audience? How do you convince the audience? What are some of your thoughts?
Very few are convinced. We are now at present 3,000 mediators,
right,
registered with the registry of the Ministry of Justice. Today, I received a phone call from a lady, desperate, saying, I have this and this case. I said, I cannot interfere and give you advices. Ask your lawyer. Yes, but our lawyer says that he cannot find a mediator. True.
That's right. And so that, again, goes back to the lawyers or the gatekeepers. So, I mean, my first suggestion probably would be, and I don't know, maybe you've tried this, and I don't know if they're all the same big firms. I would have to assume, I mean, that you got some of these big firms in Athens and elsewhere. Try to find the lawyers, the international lawyers. Try to find American lawyers who live there. Try to find British lawyers who live there and work in some of these firms who might have greater familiarity, and say, hey, we got 3,000 mediators and there's very little business. And they say they can't find a mediator. What do you think? Have you ever used it before? What do you hear about it? You're gonna have to like pinpoint certain folks, which is what we did in Texas. They found the right people to go, the right things to say, and the right legislature initially to approach, legislator, and then the right judges who might be open to this. So you have to, I would think, and maybe I'm wrong, that some of these larger firms who deal with larger companies might be more open to this than your person who's doing a divorce or who has a small business case or something like that and sees it as, we're going to lose all my business. Now, what the reality is I know no lawyers in Texas who have lost their practice because of mediation. Here's an idea. Maybe this doesn't exist there either. A couple of questions, and I think we talked about some of this in some of the World Forum, but are there any contingency fees in Greece? Meaning you get paid if you win and you don't get paid if you lose.
Regarding lawyers or mediators?
Lawyers, not mediators.
Yes, there is a contingency fee.
Okay, so here's one of your groups to potentially consider connecting with. Like most of our contingency lawyers are on the personal injury side, injury cases. There are some on the business side, or often than not, they're on the personal injury side. And they have groups of personal injury lawyers who have luncheons and things like that. You go to that group and you tell them, hey, you get the same 20%, 30%, 40%, whether you settle a case now or whether you win a trial 5 years later. Mediation is for you. Think of how much more money that you can make if you start settling all your cases after a year and you don't have to keep doing all this work. You're going to get the same fee anyway. Or another circumstance is, do a lot of people use lump sum, take lump sum fees? Give me,
yes,
whatever, 1,000 euros and I'll do this. Okay, whether that gets resolved in a day or 5 years. So go to that group and say, you're only getting this much money. Why don't you resolve it now? We're not asking you to consider some settlement that is outside of the interest of your client. Of course, you would never do that. But if you can get a result that's in the interest of your client, and you can then make all this money sooner without less work, you can get more cases. You can make more money doing this. And it's the same for the contingency fee lawyers. So that's part of the key, is figure out who to target. And there's even lawyers. So think of lawyers who are flat fee lawyers. Think of lawyers who are contingency fee lawyers. Think of lawyers like that who you respect. And you think they're decent people and maybe they have the interests of their client at stake. Explain to them why why mediation will benefit them rather than harm them. That's part of the education process, I think. Now, I will say this, and I have my opinions on this, and this probably annoys people as well, but it's my honest opinion, and I've seen the success that it's had. You finally get them to do it. And then they come to mediation and it's a horrible experience. They're never going to try it again. And that's a difficulty. I remember I had one argument. Do you know, Catherine, do you know Jeremy Lack by any chance from Geneva?
Yes, I know him.
Wonderful man, wonderful lawyer. We have argued about mediation for a long time. I haven't talked with him in a long time, but we'd have these arguments about mediation. And he was very much against the caucus model and very much in favor of the conference model. And he was in one of our programs in the World Forum. He was talking about this mediation where there were these large companies, and he says, okay, I'm going to each give you paper and pencil. Draw what you're feeling right now. And you know, I learned that that mediation went nowhere. And I said, the clients are not going to like that. The lawyers are not going to like that. More importantly, in that context, the lawyers are going to think that's crazy. As we say, it's too touchy-feely. And pardon my French, we say this in English. I don't know if you know the meaning of the phrase, pardon my French. You all know the meaning of when an American says, pardon my French? That means we've just cursed. And we say, pardon my French. Like it's French, it's not really a bad word. So,
okay.
So I'm going to curse right now. So I raised my hand in response to what Jeremy is saying. And I said, well, how did the lawyers feel about that? Well, they didn't like it. I said, well, you know, that's a problem if the lawyers don't like it. He said, fuck the lawyers. And I said, you can't say fuck the lawyers, particularly in your context, because those are your business. You have to find a process that they're comfortable with. It would be interesting to explore the caucus mile that if you can ever get somebody to try mediation, try it and see how much more comfortable the lawyers are not being. They don't want it most of the time. They don't want to be in the other room with the other side. They don't like them. They don't like their lawyer. And that's it's a big change to try to get people to consider doing something like that. But since I've done all the different types, I feel you can tell I feel strongly about it, and because I've had so much success in my practice with it as well.
May I have a question, please?
Of course you may.
Thank you very much. Excuse me, I'm a little bit darker.
Dark.
Something
okay.
is wrong with my camera.
Uh-oh.
In the case, as a mediator, in every case I have, I want to solve it.
Right.
In some cases, there are some special ethical reasons that guide me to force me to do it. Is it appropriate to have a private discussion with the client without his lawyer in order to convince him that this is for your benefit to take the path of the mediation?
Well, the only way that that would be ethical is if you ask the lawyer if they're okay with that.
Okay.
In my opinion.
First ask the lawyer and afterwards speak with the person.
If the lawyer says, I don't mind you talking with my client, then
Yes.
You're okay. But the problem is the lawyer's not going to say that. And so to me, it would be inappropriate to go around the lawyer's role and then talk to their client anyway, even if it's a way to get the case settled. And that's the problem, though. And so on the one hand, you're not going to settle it because the lawyer is getting in the other way and getting in the way. The other hand is, if you think about this practically and you think about it as a market, if you then go around the lawyer's back, as we say, and talk to their client without their permission, you're never going to see that lawyer again, at least. Maybe that client settles the case. Maybe you did a great job, but you're getting your business from the lawyer, not from the client. And so unfortunately, as much as I would like to have that happen, but that's where, if you have a caucus, you can start saying these things in front of the client with the lawyer there. If the lawyer then says, stop saying those things, then I think you have to respect the lawyer, even if the lawyer is wrong. And the lawyer's not letting the client understand the risk. And the client could lose at the end of the day because they lose their case because they didn't understand the risk and they might have been able to settle it. But that's, again, another significant advantage of having it separate, because you can go into all that as a mediator. The exact same things you would want to say to that client, you're saying with the client and the lawyer. And so that's not unethical. And you then make the lawyer tell you, don't say that anymore. And if the lawyer doesn't say that, you keep going in a positive way, in a reasonable way. You know, you can't make, if they stop liking you, then they stop listening to you. And once they stop listening to you, then, you're lost. But again, that's going to be it's somebody. It would be fascinating to get a group of mediators who would be willing to try the caucus model. Honestly, I know there was a lot of, once mediation started to become big in the US, and then it was these academicians who came all around the world and started spreading the word for mediation. And a lot of them were Americans, for better or worse. And a lot of them said things I strongly disagree with, which is why I think, honestly, much of the rest of the world doesn't do caucus model mediation, because that's not mediation. That's wrong. It's not wrong. It's what the parties want. It's what works. I fear that even if you get into mediation and they start ordering it, if you have a process that the lawyers don't like, it's potentially going to be a significant failure, and how long then will it continue to be ordered? Now, which is why also, though, I am open to hearing from lawyers who have done a lot of mediations. I mean, mediators who have done a lot of mediations, who use the conference model almost exclusively. I would love to hear from them. That would improve my practice. But what I'm curious about is how many mediators in the world, frankly, have a full-time practice doing a conference model, and how many mediators have a full-time practice doing the caucus model. And it would be interesting. I'm just not a good researcher. I'm too lazy. But I think it would be interesting to try to get a group, Catherine, at some point in time, who might be willing to explore the caucus model and, see what it's all about, and, have it, as we say, another arrow in the quiver to offer to these lawyers, especially if you go to those other lawyers from the big firms who are familiar with mediation. Most of them, if there are any, will have probably done the caucus model, will be more comfortable with the caucus model. And as mediators, we're better off knowing as many models of mediation as we can. I think what I was saying, Catherine, is I'm afraid too many American academicians came over around the world.
Thank you very much for your answer.
You're welcome. So, to have a group to see if they would be interested in learning about the caucus model and potentially offering it. I also want to say this: next year, now that I can mediate by Zoom, next year I plan on spending 4 months in the US and 4 months in Mexico, because I told you about this little house I bought in Mexico, Catherine, that you're invited to, and then 4 months elsewhere. I've checked the time zones of all these places around the world. Where could I at least do a half-day mediation from? Now, 8 hours later, I'd have to be mediating late, because mediation is going to want us, let's say, start at 9 a.m. So actually, that wouldn't even be bad if I did a 9 a.m. Houston mediation, because all of my business, almost all of it, is still in the Houston area, but I can do it from anywhere in the world. So if I go to Athens and I spend a month, the idea is I'll work half time and I'll explore half the time. But if I'm doing a 9 a.m. mediation, that would be a 4 p.m. mediation. If I worked only half a day and worked from 4 p.m. to 8 p.m., that is something very tolerable. So if you do, there's another mediator who is even more experienced than I, who was one of the best teachers I've ever had, who I turned him on to the World Forum. Catherine, did you ever meet Ross Stoddard and his wife, June? I don't know. He might have started coming. He was another Texan who had a much more of a Texan accent than I do. And he loves to travel, and he's one of the best teachers I know. So maybe next year, when I'll spend a month in Athens, and Ross and I will give a presentation on the caucus model of mediation. And okay, I think you're on mute, Catherine. I think you're on mute.
I said that then I will definitely insist for you to come. I will repeat my invitation every month.
Okay.
You come.
Now, I made the mistake one time. It was before the Athens conference, and I wasn't thinking. And so I take a little time off for these conferences. And so I always build a little bit of time before and after into going to the World Forum. So this World Forum was in the middle of March. So my idea was I'm going to show up with like a week before, and I'm going to go to the southern Greek islands. I've been to Kerkida once, but I had never been to any of the southern Greek islands. So I'm going to go spend a week on the southern Greek islands before the conference. And I get to Corinth, the Corinthian Peninsula, and there's a blizzard. And so I realized that that was not a good time to go to the southern Greek islands. And I went to one town and all the hotels were closed because it was the winter and it was cold and it was rainy. And I met some guy in the street. Unfortunately, he knocked on some hotel and said, this guy needs a room. But the point being is I'd have to pick a good month. But what we could do now, I'm willing now or soon to pick a time frame next year and a good time to visit Greece and commit to that now. Because what I've learned is if I commit now, I'll make it happen. So you and I will talk, and we'll talk about doing something like that. That way, with that much notice, I can start talking to Ross and maybe get another couple of mediators to come over to do it.
Perfect.
So we'll talk about that. And if anybody, Catherine, you have my contact information. If anybody wants to observe one of my mediations, it could be anything from a simple car accident case. And it's a very different model, mediating a car accident case. And you would probably be shocked and appalled about the things I say in a car accident mediation case, or even in some of the others. But I'm willing to let y'all do it. I mean, timing is relevant because it's so much later there. But if I have like a half-day mediation in the morning, it's easy to hook you in on Zoom. So anybody can get in touch with me if they want.
Okay.
Any other questions? Any other thoughts at this point?
I think that it is better that we leave you to continue your presentation and add anything you would like to add.
You know, I think let me take a quick look here. I think I pretty much said everything, and I'm sure you all have things to do. It's getting late there. So I think we're done. If anybody has any questions later, then please feel free to contact me, and I'm happy to help along the way. If you want to just talk more about it or get some other ideas, just let me know, because you're all in mediation because you love the process. Mediation attracts a certain type of person, I believe. And frankly, I think it attracts a positive type of person, somebody who wants to help. And so the people who get involved in mediation love mediation. That's why they want to find ways to be able to do it. And so I'm one of them. And so I love talking about it whenever, and trying to help in any way that I can. So, Catherine, it's been a pleasure and it's been an honor. I look forward to continuing the conversation.
Thank you very, very much again for this wonderful presentation, which has underlined and pointed out many things which concern us and about which we have questions and no solutions. And it is valuable. Thank you very, very much. I will take the opportunity of your kindness to invite you again at some stage to put you other questions which I have and which most of our colleagues might have.
Sure.
Anyhow, we will remain in touch.
Absolutely.
And I take for granted that next year you will be in Athens.